Good afternoon. Welcome to the Assembly Education Committee meeting of June 22nd. We are going to go ahead and start as a subcommittee because we do not have a quorum at this time. So we'll establish that quorum in just a moment. We have 18 bills on file today. That's 18 bills, and 3 of them are on consent, leaving 14 bills to be heard. The bills on consent are SB 911, SB 933, SB 1169. Those are the bills that are on consent. One bill has been pulled, and that is SB 313 by Mr. Monning. We have a very full agenda today, this afternoon, so we need limited testimony to 2 witnesses for 2 minutes each. That's 2 and 2. That's for each bill. All others in support or opposition may register their position by giving their name, affiliation, and position on that particular bill. Please observe these restrictions. Again, 2 witnesses, 2 minutes. In order to give all parties equal time. With that, we are ready for our first author, and that is going to be Senator Bell. Senator Bell, you may proceed when ready. And that is going to be file item number 5. File item number 5.
SB 884.
What's that?
SB 884.
SB 884. File item number 5. Proceed.
Thank you, Mr. Chairman.
Let me get the mic on. Sorry.
Can they hear me? Okay, there you go. Good afternoon, Mr. Chair and members. I'd like to thank you, Mr. Chairman, for working with me on this measure and also supporting the Joint Legislative Audit Committee request on this item. And we will accept the committee amendments gladly, and thank you very much. This bill is SB 884. Mr. Chairman, because I covered some of the topic last week, I'll just cover briefly what this bill does. This bill will increase accountability and transparency on how schools are spending their mental health funding by using an annual K through 12 audit process. The bill will require the Department of Education to produce a student outcome report and on mental health services components within the IEP. So it, with the committee amendments, it folds in the mental health issue with the current process, which I think will help us achieve what we're trying to do. By providing statewide transparency for mental health funding in the schools and student outcome data, California can ensure that its most vulnerable citizens children in the public schools are receiving adequate care, and I'll turn it over to witnesses.
Erica Hoffman on behalf of the California School Boards Association. First off, I do want to say thank you very much to committee staff, to the author and his staff for the amendments that have gone into this bill. We did have support if amended position on the bill at this time, pending seeing the final language. I would like to say we will be moving our position to support. We do see this bill as a way to increase the focus on meeting the mental health needs of students, and we appreciate having our concerns addressed. So thank you very much.
Thank you. Thank you. Any other witnesses in support? Seeing none. Any other members of the public in support? Come forward. State your name, affiliation, and position on the bill only, please.
My name is Cassidy Case, and on behalf of the Steinberg Institute, I support this bill.
Danielle Mollet, California Alliance of Child and Family Services, representing 130 nonprofit children's mental health organizations in support.
Kathy Rabin from the California State PTA, and we are in support of the bill.
Robert Sumner on behalf of California Attorney General Kamala Harris in support.
Great, thank you. Any opposition? Please come forward.
Good afternoon. I'm Nancy Lacoste, and I'm representing Sacramento City Unified School District and the Coalition for Adequate Funding for Special Education. And we have been opposed to the bill, but with the amendments that are being proposed, we'd like to thank the committee staff and, of course, the author very much for working with us, and we'd like to continue to work, and we'll bring it back. Once the amendments, we'll bring it back to our members and report back to you. Thank you very much.
Thank you.
Laura Preston, Association of California School Administrators. We're in the same place as the prior speaker. We're very pleased with the amendments that we've seen. We're still waiting for feedback from our members, and we'll hopefully be able to remove our opposition soon. Thank you.
Elizabeth Munguia with the California Association of School Business Officials, also in the same boat as the previous two speakers. I want to thank the author and the committee for their work on the amendments and look to continue working with them.
Hello, I'm Anjanette Pelletier. I'm with the SELPA Administrators of California, and we also are greatly appreciative of the work of the committee staff and the member staff for the intense amount of work that has gone into the amendments that are sitting here today, and we are very pleased with many of the amendments. We are also pleased to continue working on technical issues related to some of those amendments, but at this time we are continuing with our opposed unless amended position.
Madam, Mr. Chair and members, Isabel Garcia with the California Teachers Association. We also want to commend the author for his outstanding leadership on these issues. We currently haven't opposed. We think the amendments are a step in the right direction, and we look forward to working with the author on this going forward. Our concerns are limited principally to if we are already collecting data, mandating new reports for the same data is a concern of ours. And also, we don't want to increase the workload on service providers or teachers or exceed federal law in doing the good work that we're doing here. But it is an important issue, and we look forward to working with the author going forward. But we cannot remove our opposition at this time. Thank you.
Thank you. Any further opposition? Seeing no opposition, any members of the committee wish to comment? The bill's been moved and set. We can't move it even when okay, so we do have to wait for a quorum to be present. So.
Yeah, that's all right.
So thank you for your testimony, Senator.
Thank you.
We'll now move on to Senator Wolk.
Good afternoon, Mr. Chair, members.
It's file item number 15. You may proceed.
Welcome.
Go ahead. You may proceed.
Yes, Mr. Chair, members, good afternoon. Today I come before you with a bill to codify recent case law. 1343 protects students by allowing administrators and school boards to involuntarily transfer pupils who are convicted of a violent crime such as felony battery, rape, or attempted kidnapping against a classmate, even if that crime happens off campus. In 2014, Clovis Unified versus Nathan G. held that involuntarily transferring the student doesn't infringe on that student's right to public education. Options for involuntary transfer might include continuation schools that offer diplomas and a more structured setting for students, independent study, or college courses. The Constitution also guarantees a student the inalienable right to attend campuses which are safe, secure, and peaceful. And in a case from 2005, Danielle versus SV Ezra C., the court ruled that a student's right to attend a school is neither absolute nor unilateral, and that only a total deprivation of a state-given right to education would violate the U.S. Constitution. In this case, the court reiterates that, quote, there may be cases in which the circumstances surrounding a single act of violence may support a conclusion that future harm is highly probable, unquote. However, despite the recent case law, small districts with a single traditional high school are being advised that they should not enforce a restraining order, and that if the victim and perpetrator share a class, they cannot move either student except by parent request. If two high school students are at a party over the weekend and a girl is raped by a classmate, under current law, he can return to the same campus, even the same classroom, as his victim. Understandably, this can make the victim fearful of a repeat attack on campus and opens the school district to increased liability. SB 1343 will keep students safe at school and allow administrators and all school boards the option to involuntarily transfer students when issues of student safety are present, pursuant to a policy that is developed by the board. With me today is Dixon Unified School District Superintendent of Schools, Brian Dolan, to answer some questions, any questions you may have. I ask for your aye vote.
Good afternoon, Chairman O'Donnell and members. Here today very much in support of this bill. As a single high school principal, the beginning of my career in Dixon and now as a superintendent of schools, I can count 7 or 8 instances of off-campus, weekend, or otherwise outside of our jurisdiction, violent crimes in which the student who was ultimately convicted or pled to a felony or misdemeanor had the right to come back on campus and, in essence, perpetuate a hostile environment for the victim of the circumstance. I have seen the first version of this bill and the current one and very much support the adjustments to enable some process for us to work with students, both victim and perpetrator here. The idea of counseling or other interventions totally appropriate and very much in the direction that school districts across the state have taken in recent years. The idea of being able to, at least temporarily, if not on a longer-term basis, have the governing board, after adopting policy, make this determination to transfer a student to another site is something that I think would benefit victims of crimes in particular. I can think of my first instance of this, which was all the way back in my first year as a high school principal in 1998-99, where girls at a party over a boy, vicious attack from behind by one of them, and the young lady who was the victim actually left school because of this situation. Being able to help a victim stay where he or she belongs, I think, is very much in the interests of that victim and our system.
Great. Any others in support?
Erica Hoffman on behalf of the California School Boards Association, very much in support. We appreciate the work of the author and of the staff. Thank you.
Laura Preston, Association of California School Administrators. I want to thank the author and staff for working with us to make sure we have a due process for those students that are being faced in this situation. Thank you.
Any others in support? Seeing no others in support, any witnesses in opposition, you may come forward.
Good afternoon, Chair and members. I'm Liz Guillen with Public Advocates. With respect to the author, we oppose the bill. First of all, the criminal justice system has a process whereby if you are convicted of an offense and you serve your sentence, that's supposed to mean something. So then coming back to school in your community, if that continues to make you a perpetrator simply by your existence, I think that's a problem. 1343 is a one-size-fits-all approach, and it was introduced specifically to deal with this one situation. We think that it will disproportionately impact African American, Latino, and disabled students. And we know that based on the experiences of our community partners who have worked very hard and have worked hand in hand with its legislature in recent years to recognize that students involved in the criminal justice system need access to quality programs and they need transitions back into the system that welcome them. So we think this is a step backwards, and for these reasons we oppose the bill.
Hi, my name is Lillian Chen from Public Counsel. I speak on behalf of a coalition of education advocates, including Public Advocates, Alliance of Boys and Men in Color, the ACLU, National Center for Youth Law, and Common Sense Kids Action. And we strongly urge your no vote on this bill. SB 1343 would allow, even with the most recent amendments, a school board to transfer any student who has been convicted of certain crimes, regardless of whether the conduct underlying the offense has any connection with the school site or the young person's education. Instead of being an effective means of addressing the needs of student victims, the school transfers permitted in this bill would simply uproot students involved in the juvenile and criminal justice system and disconnect them from their schools, where school connectedness and stability in education are the top factors in predicting recidivism. Moreover, the criminal court systems already utilize existing legal tools to protect student victims, including restraining orders and stay-away orders. These orders can and do prevent a student from attending a certain school in a situation in which a judge, who has the benefit of a full understanding of all the facts at play, determines that it's necessary to separate the students in this way. This bill would also undo years of progress made by this legislature to ensure effective methods of reducing recidivism are the ones that are invested in this state. Therefore, for all of these reasons, we ask for your no vote.
Hello, committee members. My name is Chauncey Smith. I'm here with the ACLU of California in opposition. I would like to echo the comments of my allies right here. I completely agree with everything that they said. And we also empathize with the author and her willingness to address this important issue. However, just to sum it up, we believe that the criminal justice system and the juvenile justice system is the best place to deal with these issues, and victims can be protected through those means. This is the wrong approach. It will have a disproportionate discriminatory effect on students of color and poor students who are overly involved in the criminal justice system already. Thank you.
Thank you. Any others in opposition? Seeing no others in opposition, we'll go back to the committee for comment. Senator, thank you for this bill. I'm going to be supportive of this today. There is due process built into your bill.
There is.
And it is permissive. A district need not necessarily employ this strategy if there's problems that continue on a campus. And let me tell you why. I think sometimes it also speaks, everybody's talking about the victim, but also even the perpetrator. If this person's been convicted, it may be safer for them sometimes to be somewhere else too. I don't know that everybody picks up that dynamic if they haven't spent a lot of time on a campus. So again, I hope this legal tool is used wisely and carefully and strategically and really thought out, and that's really the duty of us to provide this tool, but also the duty of the school districts to use this tool very wisely. We need to be very, very careful with this. I'm very sympathetic to some of the comments that were made here today, but also I'm sympathetic to a victim who might be on a campus, having two daughters myself, and there's the perpetrator that shows up one day. Yeah, he or she may have served their time, but there's still that dynamic of campus dynamic that you need to keep the entire campus safe. So with that, I'm going to support the bill. Any other comments? Vice Chair.
Thank you, Mr. Chair. A question to anybody from the opposition. I just want to make sure I'm correct in understanding the opposition argument. So if I could extrapolate it to a very recent and specific example. If the perpetrator of the rape on the Stanford University campus were a high school student, are you suggesting that that gentleman should be able to be in the same classroom as the victim of his rape?
Are you saying the university student doesn't have a fundamental right to education in the same way?
I'm asking if that student were a high school student, should he be placed back in a classroom with the victim of his rape?
I think the facts there are the kind of facts that a judge should have before them in deciding a proper stay-away order or a restraining order.
Okay, thank you.
And I think someone else, the gentleman here, wanted to make a comment.
Say the same thing. The courts can issue a stay-away order. Of course, under those facts, I don't think I personally would think that's a good thing, but a judge can take care of that. There's no need for the school to get involved and start doing things on top of that.
So let me jump into another question. So if a judge can step in, wouldn't that take some time, some significant effort? Shouldn't the school play a role in that?
There's already a court case, and then this can't happen until after there's a conviction. So under the terms of whatever the judge does, you can issue a stay-away order as part of the remedy for the problematic behavior.
And if I could add, a restraining order or stay-away order could be issued before conviction.
Right.
In their interim. Yeah.
And I just don't know that totally solves the problem when you're on a school site. There's a lot of things going on at a school site, and I think they may need these tools at the district level to keep all kids safe. And I mean, you got to understand, you got to stand on a high school campus. Word spreads fast. They know who did what, be it through social media, through the old-fashioned way, talking, right? They know what's going on out there, and I look at this from a different lens than some others. I also look at the perpetrator and say, gee, is that individual going to be safe on a campus too? Just a thought. And I think there were some other comments. Dr. Weber.
I appreciate both points of view. I guess the thing I'm grappling with, and I may support this and then figure out what I'm going to do when it gets to the floor, if it gets to the floor, but having served on the school board, school boards can do this anyway, and they do. I mean, we've had numerous incidents. The school board has the authority to place students in places where they think folks will be safe, or where they think they'll be the best interest of students. So I'm trying to figure out, it seems like it was a problem happened at one school, one district that probably must not have had a very good school board. But I've been in cases, as a school board member, we have placed students in other places because we felt it was safer for them, or was safer for the students that they perpetrated some act against, or whatever it was. So as I read this and as I read the current law, school boards have the authority to do this already. So I'm trying to figure out what the issue is, other than maybe this school board needs to be told they could do it. And being on the school board or anywhere, people threaten to sue you every day. I mean, that's a part of life. If you do this, they're going to sue you. Let them sue you. But in the end, the judge will probably rule in your favor, because it would be in the best interest of students not to have them on that campus. So this is why I'm trying to, I think the school boards have the authority. I'm concerned that if we pass this, districts may think that they have some other super authority to go in beforehand rather than after the case. But I do know, having served on the school board, that we have moved a number of students that we did not think that were in the best interest of that student going back to that school because of activities that occurred at that school, as well as who was there, and so forth and so on. So school boards have the authority to do this already. So I'm trying to figure out, what would this do that would be that would be necessary, as I see this happening all the time when I was on the school board, placement of students.
Sure. So if I may, Mr. Chairman, two things. Our comprehensive high school in Dixon has just under 1,100 students. We did have a circumstance this year of an alleged sexual assault in which a restraining order was issued. We have zero capacity virtually on our site to enforce that restraining order during the course of the school day. We do our best. We met with both parents, both families, but we have no legal authority to do any kind of enforcement. We would call a parent when we would see perhaps somebody coming close to the other student, those kinds of things. So in terms of unless there's a sworn officer on that campus, which most small districts with one high school in particular, which we're talking about here, unless you have that sworn officer, we have zero capacity to do that. Similarly, with with the board transferring. So we can't involuntarily transfer a student to an alternative education program. And again, in my district and in many others, there's one high school and an alt-ed setting. So with expellable offenses, or through the school attendance review board, or through probation, you can place a student involuntarily at the continuation setting, even more restrictive with expulsion cases in a community day setting. So we don't have any ability, including to the independent study program within our comprehensive high school, we don't have any ability to place a student there directly. We don't. You don't
have a placement and appeals board in your school district that places students that you need one.
If I had two high schools, I could do that. I could do that process.
We've actually placed students on home study that we felt were not beneficial for them to be in the school environment, and that was an authority that the school board has to do.
If the parent agrees,
as well as we've placed them in other districts. Transfer students to be placed in other districts that were not, that if it were a situation where you felt that the local district was not going to be able to meet that need. But we've actually, I guess because I've seen it in the placement and appeal boards on these school districts where they can assign all these kinds of things. So that I'm just curious as to, not that I'm opposed to this concept, or maybe it gives them additional reason to, or maybe something to do it, but I've seen this happen on a regular basis, of students being actually placed in other sites, being placed in alternative education, being placed on home study, juvenile court study schools, a host of things that exist in the county, as well as things that exist within the school district. So I don't know. I just thought school boards
absent of an expulsion order by that governing board, all those placements you spoke of require parental consent.
So you couldn't do an expulsion of this child?
No.
Oh.
No violation of the education code.
No. Okay, but he was convicted of a crime against a student.
Absolutely. That student who is then in the same school, perhaps in the same classroom, and the chairman made a reference to people knowing automatically. Here's the lethal weapon in terms of the ongoing hostile environment that a victim can experience, as well as the perpetrator, right? We had an alleged incident at about 8:25 in the morning on campus. I got my first contact from the school principal about an hour later. The word was already out amongst kids within that hour.
But wouldn't your judge in dealing with this case and after in making assignments afterwards, because we've had that too, in terms of when the student is finished, whatever, if they've committed this crime, whether in juvenile hall or whatever afterwards, then would make an assignment and recommendation as to where this child should go, if they're to return to regular school, go to I mean, I've seen it happen, but I mean, and I know that it almost sounds like the school district didn't have any alternatives or options, but I've seen them have these options. Maybe they didn't take them in terms
Larger
of
school districts, I believe, have the options.
The large districts, but also the judicial system, the juvenile courts have these options.
They can place at a community day school. Correct.
Right, that's what I'm saying. So that's why I was trying to figure out, it made it sound horrible that they didn't have any options, and I'm thinking, did anybody tell them they have these other options? Okay.
Yeah.
All right. Okay, thank you.
Seeing no further comment, you may close.
Thank you for the conversation, for the discussion. I would ask for your aye vote. I'd like to see, we think that the policy that we've put together and the amendments that we've taken have protect both of the students that are involved in this very awful situation. And it's not just one school district. The size of the school districts, there are 127 that are like this, and there are probably more. As we proceeded along with this, we discovered that there were other schools that were affected by this, and we tried to come up with a policy where larger districts already have the power to do that, and the alternatives to do that. We wanted to make sure it was fair for other districts as well. So I ask for your aye vote.
Why don't we go ahead and establish a quorum? Please call the roll.
O'Donnell.
Here.
O'Donnell here. Olson.
Here.
Olson here. Kim. Here. Kim here. McCarty. McCarty here. Santiago. Thurmond. Weber. Here. Weber here.
Bill's been moved and seconded. The motion is due pass. Please call the roll.
O'Donnell.
Aye.
O'Donnell, aye. Olson.
Aye.
Olson, aye. Kim.
Aye.
Kim, aye. McCarty. Aye. McCarty, aye. Santiago. Thurmond. Weber. Aye. Weber, aye.
Thank you very much, members.
Thank you. We're going to move back to Mr. Bell's bill and take a vote only on that. We did hear that bill previously. Moved and seconded. Please call the roll on SB 884, file item number 5. Call the roll.
O'Donnell.
Aye.
O'Donnell, aye. Olson.
Aye.
Olson, aye. Kim. Aye. Kim, aye. McCarty. Aye. McCarty, aye. Santiago. Thurmond. Weber. Aye. Weber, aye.
The bill is out. Thank you. With that, we're going to move to Mr. Allen, file item number 7. We'll go with SB 916.